Welcome to where we break down complex legal concepts into bite-sized information. Today, we're discussing an intriguing aspect of the law: the limited exception to the rule that generally shields municipal governments from punitive damages. This exception is often referred to as the Note 29 exception. Before we dive in, let's understand the background. Generally, punitive damages are not imposed on municipal governments. This is based on the principle that these entities represent the public and that punishing them with punitive damages would effectively punish the taxpayers themselves. However, in the landmark case, City of Newport versus Fact Concerts, Inc., the U.S. Supreme Court established an important precedent. The court considered whether municipalities should be exposed to punitive damages under 42 U.S.C. Section 1983, which provides a remedy for civil rights violations too. It was in the footnotes of this case, specifically Note 29, that an exception to the municipal immunity from punitive damages seemed to be considered. The court acknowledged that Congress had the power to change the common law doctrine immunizing municipalities from punitive damages if it wished to do so. This referred to possible exceptions when a city's actions could be considered egregious or outside the scope of its legitimate functions. Now let's look at what that means. By setting a high bar for introducing punitive damages, the court isn't saying that municipalities can never face such damages. Instead, it suggests the potential for an exception under extraordinary circumstances. However, this interpretation is the subject of debate. The language of Note 29 does not explicitly provide an exception but rather leaves open the chance that Congress could enact one if it chose to. As of the date of recording, the exception hasn't been clearly defined or widely implemented in practice. This ambiguity leaves lawyers and scholars debating the extent of municipal immunity and under what specific circumstances a municipality might be exposed to punitive damages. Do these circumstances only relate to civil rights violations under 42 U.S.C. Section 1983, or could they extend further? In conclusion, while municipal governments are generally immune from punitive damages, the City of Newport versus Fact Concerts decision and Note 29 within it imply that there might be narrowly defined instances where this immunity could be waived. Could the punitive damages immunity for municipalities change in the future? That would depend on congressional action or perhaps a landmark court decision that directly addresses and clarifies the Note 29 exception. For now, though, the doctrine of municipal immunity from punitive damages stands firm with only the faint hint of a possibility for exception lurking in the pages of legal history. Remember, laws and interpretations can change, so it's always essential to consult legal expertise for the current state of play. Thank you for joining us, and don't forget to hit the subscribe button for more legal insights.